Today, you are going to hear from myself, Rebecca Dobbs-Bush, and my partner, Kelly, who is also on the line. Hi, Kelly.
Hi, Rebecca.
So we are here today to talk about the American Rescue Plan, because that's what we all needed, right? Another statute to read and learn and remember. It's definitely keeping us all on our toes, keeping us busy, but there are some, out of the 600 some plus pages, what in here as an employer do you need to know or you need to be aware of, like the top items? And that's kind of what we're going to cover today, giving you some details and so that you can get started with your organization and preparing and figure out what best applies to your situation. One thing, I wouldn't be a good lawyer without my disclaimer. So notice at the end that this is current through today's date. And I have to emphasize that more than anything, because especially with the regs and things we're discussing, there is clarifying guidance forthcoming, and things do take twists and turns as we evolve. I'm sure many of you are familiar, for example, with the PPP loan, the different definitions we got, how different agencies come out with clarifying guidance. But to go a little bit more into what we're going to talk about today, the American Rescue Plan Act of 2021. This was signed into law by President Biden on March 11th. So just less than 2 weeks ago, I guess. Wow. The days all blur into one during this lovely COVID pandemic era. The first item, I tried to organize this with Kelly. We tried to plan this for, people of all sizes here, or recognizing that people of all sizes would be attending, companies of all sizes. And so first, we're going to go over the COBRA subsidies that are addressed in the statute. And this affects employers of all sizes. If you are subject to COBRA continuation, you need to understand this provision of the Act. The second and third items that are really the top highlights, there are, a few other provisions, miscellaneous provisions in ARPA that affect benefit plans tangentially or different little tweaks here and there. But the other two biggies that we wanted to make sure everybody walked away with knowledge of their impact in American Rescue Plan is the Employee Retention Credit and the FFCRA tax credit. So if you have less than 500 employees, and generally that's for the Employee Retention Credit, it's, how is your company, if you have affiliated companies, how is it lumped together based on, for example, how you do your discrimination testing for your 401k plan is an example, because it defers to 414 of the tax code. But the idea is I wanted to break this apart so that, if you aren't concerned about those two, you can get the meat of what you want today and understand the biggest provision in the American Rescue Plan that impacts your operations right away or within the next, week and a half here. And you can get the meat of that without having to sit through the other stuff that may not apply to you. Now, I will say Employee Retention Credit, I put it primarily as helpful for employers with less than 500 employees because there are still retention credits for those of you with more than 500 employees. It's just different because you only get credit for wages paid to people not working. So primarily this can come up with if you're paying health care for people that you've laid off. However, guess what? If it's an involuntary layoff, you may not care about the Employee Retention Credit anymore because for the next 6 months, you're going to be able to use the COBRA subsidy to supplement that instead. So just an outline of where we're headed in the next hour. I have some questions already on the COBRA subsidy, so I can tell it is a big topic here. And the one question I just got, it will be addressed. So let's get started. Subtitle F of the American Rescue Plan Act was titled Preserving Health Benefits for Workers. This was not a recreation of the wheel, as I note. For those of you who were traumatized in 2009 by the American Recovery Reinvestment Act, which also dictated COBRA subsidies, this is clearly, anyone familiar with that, which was way before the ACA, which was a note to myself of just, wow, that was a while ago now when COBRA had a whole different meaning because of pre-existing conditions and the impact of that. But for those familiar with that, this should also be very familiar. There are some tweaks and changes along the way. It's not identical to that, but there are similar terms that you may remember, such as assistance eligible individual, a similar structure with payroll tax credits addressing the subsidy of COBRA premiums. Back then it was 65-35, I believe, in terms of a split for the employee only picking up a portion. So just a high-level executive summary to get started. I think that's sometimes helpful so you know how all the pieces are going to fit together. So if you are an assistance-eligible individual under this provision of the American Rescue Plan, you will have 100% of your COBRA premium subsidized. This subsidy is available for policy periods or coverage that is provided between April 1st, 2021 and September 30th, 2021. Employers will receive a refundable tax credit. That means if you don't owe enough tax, the money will come back to you nonetheless in a refund. A refundable tax credit, it'll reimburse for the amount of premiums incurred, and that credit is to be applied against your quarterly Medicare taxes reported on your 941. There is a process to get advance payment, but and if you're interested in that, I can provide you with more information. In most cases, people are able to reconcile it with their quarterlies and address it through that. So I've had very few employers trying to deal with the advance credit. Premium subsidy, this 100% coverage is not reportable as gross income for the assistance eligible individual. You'll see that AEI, which means the person getting the subsidy, right? Whoever's eligible. The assistance eligible individual is going to be an acronym I use throughout these slides. But this is not taxable income to these individuals. Okay, so breaking down a little bit more about which specific premiums does it apply to. The subsidy applies to all, quote, COBRA continuation coverage. So, like I said before, this impacts employers at the largest size because COBRA continuation is for anyone who has a group health plan and is offering then continuation under the terms of the federal law. Now, in addition to that, just like with the prior subsidy we dealt with in the past, the rescue plan, the American Rescue Plan also defines quote unquote COBRA continuation coverage, or to include continuation coverage under a state program that provides comparable continuation coverage. So for those of you, for example, in Illinois, we have Illinois continuation law. Most states have a mini COBRA or a smaller continuation law that provides for the continuation of healthcare coverage. And in those cases, that coverage would also be subsidized by this provision of the Act. So again, applies to all employers of all sizes who have group health plans. You just have to be providing the coverage pursuant to a continuation law. The premium that you can get subsidized includes the 2% administrative fee. So if you are charging 2% on your premium, it does get included in terms of the reimbursement rate. You can include that in the amount you're seeking reimbursement for. Now, I saw this question. Most of the questions that are coming through, we are going to be addressing. All of the COBRA ones I've seen so far come through. So just wait one sec. So who is an assistance eligible individual? That is an individual that has experienced a loss of group health plan coverage due to an involuntary termination of employment or because of a reduction of hours, and that person elects COBRA continuation coverage. Now, what if they didn't elect COBRA continuation coverage? So there is in the statute an 18-month look-back period to November 1, 2019. And that is going to, for any individual who's been involuntarily terminated or had a reduction in hours, you're looking backwards in your records to November 1st, 2019, for those individuals. And if they did not elect COBRA at all between that period, they still are going to have an opportunity to start for whatever, I think it's 1 or 2 months left in if it was a November 1 termination, they might only have 1 or 2 months left, but they would be able to get that under the program as an assistance eligible individual because they're still within their COBRA continuation window. They're still within that duration of continuation. You can also have someone in that look back period if that elected COBRA but discontinued the coverage. So it's someone who declined, or they elected COBRA and they discontinued it because of non-payment, or which is hard because of the extensions. But say that you understand their discontinuation was was at the employee's election for whatever reason, cost, what have you. And we're going to describe the notice that goes to these people in a later slide. Who is not an assistance eligible individual, right? I emphasize that somebody who involuntarily resigned or had a reduction in hours. So this does not include people that voluntarily resigned. I saw a question if the gross misconduct exception still applies in this case. And yes, that is the case. But I have never, I want to say never, maybe I'm pretty sure it might have been once, but it is a rare occasion when you can apply the gross misconduct exception in COBRA, and there's not a lot of guidance on it. So if you're going to go that route, I'm sorry,
I didn't mean to interrupt you. Yeah, it's a really high bar. It has to be something detrimental to the employer. Potentially stealing, we saw a question, but I think it would have to be a really significant, egregious situation.
It's really egregious. And what I would recommend is, I'm not saying you can't use it, but I'm saying if you're going to rely on that to cut someone off from a subsidy that the government wants to get to people involuntarily terminated, that you would make sure you have counsel review your specific situation. It's not the same as, willful wanton misconduct and unemployment or things like that. So you just want to be very cautious if you're relying on the gross misconduct exception in COBRA. But yes, if they do fit under that, and I'm not saying it's impossible, if they do fit under that, they would not be eligible for this. And if they voluntarily resigned, they would not be an assistance eligible individual. If they lose coverage for reasons unrelated to involuntary termination. I had somebody ask me the other day, well, I have a child dependent aging off the plan. I'm like, no, they're not losing coverage due to related to an involuntary termination of the participant. So if they lost coverage due to divorce, things like that, you are not eligible as an assistance eligible individual. So you are also not an assistance eligible individual if you have since obtained the ability to participate in another group health plan, or if you've since obtained the eligibility to participate in Medicare. Now, how are we going to know this, right? This is only on the employee. So the Act does specify a penalty for, and here's the kicker, quote unquote, intentionally failing to notify the employer of disqualification of eligibility. That penalty is $250 or 110% of the premium assistance provided after termination of eligibility, whichever amount is more. In most cases, I would imagine it's going to be 110% of the premium assistance provided, would be the greater number. But that is also going to be something we have to notify individuals of, is the ramification. Kelly, if you could, I'm getting I see a lot of questions coming through on the Q&A, and some of them were ahead of the slides, and I know you're looking at them. If you can just help me when I get to the end of the COBRA section, point out any ones that we didn't get to so we can address them while we're within the COBRA slides.
Sure.
I'd very much appreciate it. Okay.
I will.
Thank you. So how many months is an assistance eligible individual eligible to receive assistance? So the American Rescue Plan did not extend the length of COBRA continuation available. So if I'm a regular COBRA qualifying event and I get 18 months of COBRA continuation, I don't get any longer under this act. The premium assistance is only available for coverage periods between April 1 and September 30th, or until the individual exhausts their COBRA continuation rights, whichever comes sooner. So I give you an example here. The employee terminated December 31st of 2019. The employee did not elect continuation coverage. They chose not to. They passed on it, right? Very common scenario. As of April 1, this individual would have been, had they, they're still in technically, they'd be starting their 16th month of COBRA continuation. I counted this last night, so don't fault me if my months are a bit off, but I'm pretty sure that's their 16th month of COBRA continuation. Then, assuming my counting is right, the individual would get the notice I'm going to talk about in a minute, and they would have the opportunity to elect continuation coverage starting April 1. And then those premiums would be subsidized through their 18th month of continuation, expiring June 30th, 2021. So it's kind of an open enrollment period for COBRA, if you will, in terms of people will have the ability to get back on. Sometimes, if people do try to get on COBRA, they have to catch up all the prior months. They do not have to catch up prior months with this. They can come back on effective April 1. This is an optional provision in the Act. Employers don't have to do it. I don't recommend it, but I'm not going to just say, oh, well, I don't recommend it, so forget it. I still want to educate all of you on this option. Employers have the option, not required, but have the option of allowing assistance-eligible individuals the opportunity to change coverage options in conjunction with electing COBRA. So you get 90 days. Somebody on COBRA has 90 days to change their options. So what does this mean, right? I have the slides here, which as someone is asking, the slides will be distributed later. All of this will come through. So don't feel the need to take pictures of the screen or write things down or what have you, because you'll be getting a full copy of these slides. Say I was on COBRA and, I'm electing what I was in, which was the PPO option. And as of January 1, I was included in my employer's open enrollment. And because I was paying COBRA out of pocket and I'm laid off, I don't want to cover a higher cost, I went down to the HMO option or the cheaper option on January 1. Well, this would give me the ability to go back to the coverage, the more expensive coverage I had at the time of my qualifying event, beginning April 1. Which my bottom bullet point there kind of sums that up. In other words, this option would only be meaningful to those that have the opportunity or reason to enroll in a cheaper, lower level of benefits during their continuation period and now want to go back to the higher one. You can't just go up to the Cadillac plan if that's not what you were at the time of your qualifying event. It has to be that you were at you're switching back to what you were originally enrolled in at the time of the qualifying event. So written notice, what is required? Okay. Written notice is required about the availability of premium assistance. And yes, you have to give notice retroactively to individuals within that look back period I described back through November 1st of 2019. The notice is going to have to include the description of the option to enroll in different coverage if that's something you're offering, which I just described on the last slide. It's also going to include a description of the obligation for the individual to notify the plan of eligibility. This is about the penalty. If I'm eligible for another plan or if I'm eligible for Medicare, you got to give that participant a warning of, look, you got to tell me this or you're going to get hit with this this tax or penalty for taking the subsidy when you weren't entitled to it. Now, breathe a sigh of relief because these aren't notices we have to draft right now. Under the Act, the Department of Labor is required to put together model notices, just like you have your model COBRA notices that we all fill in the blanks and use. They're required to put together model notices for employers within 30 days of enactment of the Act. So remember I said in the beginning, President Biden signed the law on March 11th. 30 days of enactment would be April 11th, I believe. So that means sometime in the immediate future, we're going to be getting model notices from the Department of Labor about this notice of availability of the premiums that we'll be able to rely on. Now, we have time because the subsidy applies to coverage periods starting April 1, but employers have 60 days from April 1st. Okay, that's the wrong date. I'm a dodo. This is what happens when you type at night. 60 days from April 1st. It should be May 30th to distribute the required notices. So you have 60 days from April 1st. So remember, if the Department of Labor is going to be distributing the notices in the next couple of weeks, maybe sooner, then we have plenty of time. We have 2 months. Our 2-month clock has not even started yet to get those notices out. And I will see, we'll change this. I'm going to put a note to myself to change the date when you get the full copies of the slides to May. It should be May instead of March. Okay. Now, you're going to be sending these out the same way you send other COBRA notice requirements, other things. The default rules of ERISA that we all know and COBRA are not changing, right? So notice require plan distribution of documents, things like that are still the same. Now, there's another notice that's required. The second notice that's required is to inform individuals of the expiration of their period of eligibility for premium assistance. So giving them a warning of, do you have to, your subsidy's running out. Now, again, take a deep breath because this is not a notice we have to create. This is something that the Department of Labor has 45 days from enactment of the Act until April 26th. Now I'm double checking all my dates because I'm paranoid, to provide model notice for employers to use. So it's 45 days from March 11th, the date the law was signed, to provide the model notice where you're warning where you're warning individuals that their subsidy is about to expire. Okay, so that's a lot of information to unpack in terms of the assistance, the eligibility, what's out there. I want to give you kind of a to-do list or things to think about in wrapping this up in this section. So first, if you're utilizing a TPA or any third party for COBRA administration, the very first thing you want to do is check with them to determine whether this additional notice is part of your service contract or not. I've had some willing to administer it, some for an additional fee that it wasn't included and everything like that. But you don't want to be sorting this out a week before your deadline, right? And just assuming things are in place. You want to make sure that communication happens and you know who's sitting ready to distribute. Because I talked about the look back period, for now, you also, while we wait for the model notices to distribute, you want to go back and you want to review your records of your employee separations back through November 1, 2019, determine which individuals, had qualifying events related to involuntary termination or reduction in hours. And if it wasn't a voluntary resignation, it's involuntary. Okay. So unless someone said, I'm leaving, I quit, it's an involuntary termination. You cannot take a double credit where there's an overlap with the employee retention credit or the FFCRA tax credit. So we're going to go into those a bit, but there are provisions in those where you're getting subsidized for potentially the cost of continuation coverage. You would want to review with your accounting department and whoever's filing your quarterlies to make sure that, quote unquote, double dipping doesn't occur. You can't take double credit for the payment of any in some cases, it shouldn't be an issue because, for example, in a lot of the FSCRA, well, it just depends, because if it's a reduction in hours and a loss of coverage, and you just want to make sure you're not double counting. You want to also review any existing severance agreements for previous commitments to cover the cost of coverage. Now, I noticed that bullet point is ambiguous. For those of us familiar with the prior, the first time the subsidy came around in 2009, there was a provision in the regulations that clarified that if you had a existing employer obligation to cover severance, that you couldn't then pretend that obligation didn't exist and have the subsidy pick it up. We don't have any clarifying regulations or FAQs from the Department of Labor yet in regards to this provision of the American Rescue Plan. So, depending on if the Department of Labor, they may interpret the act to have a similar requirement or a similar issue, and the Department of Labor certainly has that authority, and the IRS, in conjunction with the IRS, in terms of administering the tax credit. So you want to make sure that you're aware, at least at a minimum, for when those rules that do come out. For now, you can, if it's an involuntary termination, there's nothing saying that you can't claim the credit. But you do want to be aware of those and what's out there and existing to make sure you're prepared if and when that guidance comes out clarifying. Kelly, do you want to help me navigate these questions at all? Is there anything that we should go back over before we switch?
Yeah, there's just a couple. I was still trying to get through them. One question was, does this apply to COBRA for dental and vision, or is it only health?
It applies to your COBRA. It applies to, I believe it applies to dental and vision as well.
Mm-hmm. I was taking a look through the regs. That's my interpretation too. Not very specific, though.
No, it's not very specific. And what I would tell you, the reason I believe it applies to both is because ERISA refers to health and welfare to encompass dental and vision. So that's why my initial assumption is that it's covered unless we receive other information.
Yes. Another question we had was related to how this works with multi-employer plans. And I can answer that if that is not something, if you want me to go over that, or I can talk to you too.
Whatever. If it's easier, you want to go to the question and the answer, that's fine. Whatever.
All right. So for a multi-employer plan, so the question was, do they get a credit for the amount that they're paying, contributing to the health plan? The general answer is no. So the entity that's responsible for the cost of this premium subsidy in a multi-employer plan is the plan. So the employer won't have to, pay. In a single employer plan, it's the employer who's going to pay the COBRA, so the employer gets the subsidy. In a multi-employer plan, the entity is that plan, and they will pay the subsidy, and then they will be eligible for the tax credit. So there's nothing that an employer in that situation needs to do.
Right, which is typical because the multi-employer plan administers the COBRA as well.
Yep.
Was there anything else that we didn't address? I know a lot of them came through and you either addressed them or we covered them.
Yeah, and I'll try to continue to answer a couple of them while you do the employee retention credits. Okay. And some of these are, double, let's see. There's a question about local government. Does this apply to local government?
Anyone who is subject to continuation.
Yes. Okay.
Yes.
Okay. I think that's it for now.
Okay. All right. So let's go on to the next. The evolution of the employee retention credit. So I am going to go over this in a way, in the best way I can to make sense of it, because this is so hard, and as if taxes weren't complicated enough, we have the additional complication that this was implemented, or now we're reading through this in 3 separate sections, right? So originally the employee retention credit was enacted through CARES in March of 2020. And most people didn't care about it because, a lot of people didn't care about it because there was a certain rule about, who could, most people could only enjoy the benefit if they were paying people to not work, which was not entirely helpful, or, people were trying to just pay people to do remote or keep busy or do something else versus just paying them to not work. Also, the credit expired initially at the end of 2020. So we go to then the end of the 2020 calendar year, and you have the Consolidated Appropriations Act of 2021, which dramatically changed the employee retention credit. And we did cover this in a prior webinar called, I believe it was like Stimulus 2.0 Employer Boot Camp or something, where we talked about, and that may be available if you're interested or still need that webinar to share that recording if you didn't attend it. But I'm going to go over the changes only because we need them to understand the implications of how it was then extended through the American Rescue Plan. So to summarize, we initially didn't really, it was the sleeping surprise, I guess, of CARES because nobody really fussed over it. And then the Consolidated Appropriations Act made it something we suddenly cared about, at least for Q1 and Q2 of 2021 for when it was extended. And then now we have that extension all the way through the end of 2021 when you can possibly take advantage of this. The next slide you'll see, I want to describe, to try to understand this in the context of these three statutes, I have the red line changes are from those amendments through the Consolidated Appropriations Act. And the reason I left the slides as is because some people are still caring whether or not they were able to get it in 2020, because the one change in the Consolidated Appropriations Act that I did not have clarification on at the time of the prior webinar, but the only change that really meaningfully impacted retroactively was you weren't excluded if you were a PPP loan recipient. So for some, they are now going back through 2020, and we've gotten some guidance from the IRS, and they're deciding if their revenues were down 50%, if they can take it, or if they were partially shut down for a period, if they can then file an amended, a 940X to amend and get credit retroactively for 2020 wages paid. So that's why I left the slides in kind of an edit form like this, right? So this grayed out provision here, 50%, that's the original, the stricken gray is the original text of the act. So this credit is 70% of qualified wages. $10,000 of qualified wage maximum per employee for each quarter. And then it's for all wages paid after March 12, 2020, and now extended through for the third extension. You can see it's now been extended to any wages paid prior to January 1, 2022. So the red line crossed out is where the American Rescue Plan has kicked in. The eligible employers, it's also kind of nice to have the red text as well, because that's really the meaningful, I think, it's a lot of the highlights points are the same as italicizing or underlining, right? So are your operations shut down? Are they partially suspended? The IRS has recently given notice of this because it's an either or. Either your receipts are down or you were fully or partially suspended. And the IRS just gave notice in 2020-21 about information on who is fully or partially suspended operations. And in some cases, if you're implicated or if your customers, suppliers have trickled down to you in terms of implicating and shutting down your operations, you may not need, and you have that government order in effect that restricted your operations, either, like I said, for you or for a supplier or a customer where you were impacted, it's an either or. So it's either that fully or partially suspended requirement or your receipts are down 20%. And you're comparing it to either the same quarter you're comparing it to, it's the same quarter in the prior year, but it's the same quarter in 2019. We're looking at everything in 2019. So you're looking backwards to, you have the option to do that. And if you've dropped at least 20%, then this is something you want to look at. And again, it doesn't matter if you took PPP money. It only matters if you're using PPP money to pay wages. Then you can't claim those wages towards an employee retention tax credit. Those wages then are not quote unquote qualified wages. So what does this slide mean? This slide means the number changed from 100 FTE to 500 FTE. And why do you care if you have 500 FTE? Because qualified wages, the definition changes depending on your number of FTEs. If you have an employee not providing services, that's the only time if you're over 500 FTEs that you can claim. So if you're paying layoff, if you have less than 500 FTEs, then it's wages paid to anybody, including, wages for actual hours worked. We don't care. It's just wages. And here's an example under the old credit. The long and short of it, Bob ends up and this is a slide that was in the last presentation. If any of you attended, you can see it's unchanged. In terms of Q2 of 2020, Bob earned $15,000, capping out at $10,000. So it was a 50% credit. You get $5,000 credit in wages. All of this for 2020 has not changed. The only thing that changed is that you can now do this even if you got PPP money, right? You're not disqualified from the program. So under the expanded employee retention tax credit, now we don't care if the company has as long as they have less than 500 FTEs versus 100, they can claim up to $7,000 credit because it's 70% of the maximum of 10,000. So you can claim Bob earns $15,000 a quarter. Qualified wages under the program are capped at $10,000. So you can only claim $10K of Bob's wages. So that means this employer ABC code gets $7,000 credit for the employee retention credit because they're qualified. They either had a drop in receipts of 20% or they were shut down during that quarter or for part of that quarter. So, and it goes to the quarter you're applying for. So if they're shut down for all of 2021 or partially shut down, or if they have the drop of 20% in revenue or receipts for all of 2021 for every quarter, they're going to be able to get this $7,000 credit for Bob every quarter, assuming Bob is still earning $15,000 a quarter, it's up to the $10,000 in qualified wages. So, with up to 500 employees, this can be a very meaningful credit for a lot of employers if you can fit into the window. And the government shutdown order can come from a local health department suspending operations. If you're shut down any part of the quarter, it's considered your shutdown. It can come from a local official. So some of you if you're in Chicago, there's a lot more restrictions. Businesses in more heavily restricted areas are more likely to benefit this than the ones who don't have restrictions. If you don't have a lot of restrictions in your area or your customers or suppliers don't have a lot of restrictions, then you're likely going to need that drop in the receipts in order to qualify for the eligibility for the credit. A couple additional provisions for the employee retention credit expansion under the American Rescue Plan. There's an exception for now severely financially distressed employers. So this is if you had at least a 90% decline in gross receipts, and again, we're looking back at 2019. If your 2021 is 90% down, you can take all wages paid during those quarters into account. No $10,000 cap. And the limitation for 500 FTEs is removed. So, but again, you're in pretty bad shape if you're in this category, and you definitely need that meaningful credit expanded. The recovery startup business, this is for, a different provision was acknowledged in the employee retention credit for new businesses that began operations after February 15th. Those that had an average annual gross receipt of up to $1 million for the year, they are eligible for potentially up to a $50,000 credit per calendar quarter. I didn't go into detail in these because it's one of those things where it was expanded, but it's a minor. It doesn't affect as many, I should say, not a minor change, but it doesn't affect as many that I would imagine on this webinar. So I put those there as like a highlight. If you need more information on them, let me know. Kelly, do we have any other questions to address before we move on to the FFCRA, or how are you doing over there? I see you writing back and forth with people very busily.
I know. Yeah, I'm good. There was a question about, well, first let me say, before I answer that, there have been a couple questions with really specific scenarios, and I need to say it's difficult for us to answer that in this kind of forum. So there are certain scenarios that you might want to follow up with after this webinar. If we don't get an answer back to you, if they're really fact-based, we'd want more information. Yeah. And then another question is, does this apply to FSAs, the health FSAs?
No. COBRA?
Yes, I'm sorry. Yeah, the COBRA subsidy. I'm still in the COBRA subsidy.
No, it does not. It does not.
Okay. And I think that's really, unless there's a couple, there's still been some more questions about the involuntary termination.
Involuntary termination is a big one.
Yeah, reiterate that again, maybe.
Here's how I would look at it, is that this is not money coming out of, I'm not saying let's, be fast and loose with the government funds, right? And my focus as an employer is, are you committing tax fraud or not, right? Because at the end of the day, you're getting a tax credit for this. So did somebody involuntarily terminate? What is your classification as a business for involuntary termination? And that's all you can rely on for now. I'd be shocked if the Department of Labor doesn't give a bit more guidance on this, because they did the last time around. There also was a process the last time around, which I could see if, they want to dig it out of their closet and implement it again. It was an expedited review procedure. Do you remember that? It was an expedited review procedure that was like 60 days or something, and you did it online and you disputed. But if you have questions, if you think your focus should be on, am I committing tax fraud or not? You don't want to do that, right? But otherwise, it's not about sticking it to an employer or making sure they don't get something. You really want to focus on just, hey, is this a legitimate tax credit for us or not? And try to stay as neutral about it as possible, because that's how it's designed and worded and drafted. COBRA is not a punitive statute. So it doesn't really matter what your opinions or beliefs are in terms of whether or not someone deserves it, because the legislature has spoken. So that ship has sailed. So, if somebody was fired because they stink at their job, that's an involuntary termination. And you give them, you treat it as such. It was not their choice. So, I would tell you to look at that and from a COBRA perspective. And I would caution you that before you go under the route of saying this person is not eligible for the subsidy because they were not involuntarily terminated, or it's gross misconduct, or it was, that you make sure you reach out to counsel and verify. Yes. I just had a question about job abandonment, and I would say I view job abandonment as a voluntary termination. People choose not to just come into work, but I would want more facts. This goes into, Kelly, we could do this all day, and we don't want to obviously take that time up. We want to cover FFCRA, but I would encourage you, even in that, before you classify and say this is resignation, ask the questions, because job abandonment can be a wide category in terms of, do you have any inclination why they stopped showing up, or what are the specific details? But that's what I would focus on. If you're going to go the route of denying someone based on that, and any ambiguity, make sure you take a clear position review with counsel, because it's not something you want to then be stuck wasting your time like defending or trying to get back to the employee, when really it's just a matter of reporting it on your 941s or not. So, all right, Kelly, I'm going to turn it over to you.
All right, absolutely.
To move on.
All right, so we'll talk a little bit about the paid leave tax credits under the Families First Coronavirus Relief Act back in, about a year ago now. It's so hard to believe. As you all remember, so at that time, or during most of 2020, employers with less than 500 employees I'm still on slide 23.
I know, I'm sorry. I was trying to roll to look at the questions, and it made me move the slide.
I'm sorry.
I apologize. I'll stop.
All right. So employers with under 500 employees, most of them, were required to provide paid leave for a number of COVID-related reasons. I'm sure you've all been dealing with that all of last year. there was a refundable tax credit available to offset the cost for that. That mandate to provide leave expired at the end of 2020, December 31st. What the American Rescue Plan Act does is it is extending, well, let me back up. So previously, the ability to receive a tax credit for leave provided voluntarily under the FFCRA was extended through the end of March. So while employers were not mandated to offer that leave, if they chose to do so, they could claim a tax credit for the cost of the leave. That has been extended through September 30th now with the American Rescue Plan Act. And then there's been a handful of changes to the FFCRA provisions that we'll talk about here. So again, this is voluntary. It's for employers that choose to continue to offer the paid leave and receive a tax credit for doing so. Okay, next slide. So as I said, employers can voluntarily choose to grant the leave for qualifying reasons and take tax credits for that cost. We'll talk about those amounts, the pay that employees need to receive, and the amount of tax credits employers can claim in a few slides. This does include both paid sick leave and paid emergency FMLA leave. So if you recall, there was some kind of two buckets to the leave, and we'll continue to kind of talk about them and think about them in these two separate buckets. So there's the paid sick leave, which is available for a variety of reasons, and then the paid emergency FMLA. A big kicker here is that in order for an employer to receive the tax credit for providing paid leave under either the paid sick leave or the expanded FMLA, the employer needs to comply with all of the paid leave provisions of the Families First of the FFCRA, as it's been amended since then, as if it were in effect at the time, meaning at the time of the paid sick leave. And so what that means, as an example, if an employer is going to offer paid sick leave to an employee for one of the coronavirus-related reasons this April, say, in order to be able to receive the tax credit, the employer has to be complying with all the provisions of the FFCRA paid leave during that time in April. And where that really comes into play is that we get a lot of questions about whether employers can offer this for some reasons and not others. And I'll talk about that more when we get to the reasons slide. There's not any guidance on that at this point. This particular provision in the Act that says that employers must comply with all the provisions of the Act leads me to believe that an employer is not able to, say, pick and choose which reasons they're going to offer this leave for, that they have to comply with the whole Act or in order to get the tax credit or none of it. It'd be great if there was some guidance on that. We'll have to see what happens.
And Kelly, one thing is that I saw a couple questions while I flipped aside, a couple questions about how if somebody did the initial extension in the first quarter of 2021, they don't have to continue this through the American Rescue Plan Act extension, correct? Correct. And our interpretation is you can stop at any time. There's nothing at this point stating that once you're in until the end. You can determine May 1st that you're not going to offer it any longer, or leave it completed at March 31st if that's your decision. And someone has asked if you received a PPP loan, if you can still receive tax credits, and you absolutely can and should. You just can't claim them in regards to wages that are paid with PPP money.
Yeah. Yep.
Because it'd be double dipping. It'd be getting the money from PPP to pay the wages and then getting a credit for the wages through your quarterlies. You can't do both. So,
yeah. But yeah, we see a lot of clients kind of layering these tax credits on where they can. So I don't mean layering them on the same wages, but if you've got somebody on sick leave, you can take the tax credit for that, what you pay them while they're on paid leave. Then for employees, not on paid leave, or the same employee for the weeks that they're not on leave, you may use those wages, pay those wages with the PPE loan money, et cetera. Okay. All right. So the qualifying reasons for the paid sick leave. So one of the updates to the law that the American Rescue Plan made was there are a couple of new reasons. I've broken into two buckets. Some people will say there's three new reasons. It depends on how you slice and dice the law. But they're highlighted in red here. So before the American Rescue Plan, employees were eligible for paid sick leave if they were unable to work or work from home. So they can't work at all because the employee is subject to a quarantine or isolation order, has been advised by a healthcare provider to self-quarantine, is experiencing COVID symptoms and seeking a diagnosis. That would include seeking a test. Or the employee was caring for somebody who's subject to quarantine or is self-quarantining, or is caring for a child whose school or place of care was closed, or a child care provider was unavailable because of COVID-19. There was also this, extra bucket reason, any reasons put out there by the Secretary of Health and Human Services, but they have not added anything there. So we can ignore that. What the American Rescue Plan Act has now added is these numbers 6 and 7. So an employee is also eligible for the paid sick leave if they are seeking or awaiting results of a COVID test or diagnosis, and one of two things. They've been exposed to COVID-19, or the employee's employer requested the test or diagnosis. So this is a little different than number 3 that's already in there. At first I was kind of like, isn't this just the same thing as 3? But 3, they have to be experiencing symptoms. So this is if somebody's not seeking or not experiencing symptoms, but they've been exposed or their employers requested them to get a test or diagnosis for some reason. They're eligible for the paid leave. And then the other reason is if somebody is obtaining a COVID vaccine or recovering from side effects, essentially, from receiving such vaccine, they're eligible for this leave as well.
And to clarify, these additional reasons are only applicable to time off for these reasons beginning April 1st.
Yes,
so
thank you.
If you had, yes, so if you had somebody, because people are taking off to get their vaccines now, which is great, but that's not FFCRA yet.
Correct. Yes, these new changes go into effect April 1st. Okay,
right,
and
because it's done. Okay, and because it's done on the quarterly, that someone asked if it's retroactive, you can't go back. It's based on the quarterly wages you're reporting on that 940. So you have to wait for April. Yeah.
Okay, so how much paid sick leave do employees get, and how does that work with the tax credits? So if you'll recall, the original act allowed employees, full-time employees, up to 80 hours, 10 days, for any of those reasons that we listed. And it's prorated for a part-time worker. I'm going to try to go fast here. We're near the end. One of the changes that that ARPA made is that 80-hour maximum resets April 1st. So, and what that means is if there was an employee who took 80 hours during 2020 for one of those reasons and you paid them sick leave and you claimed tax credits, if you are voluntarily extending this program, that employee beginning April 1 would be able to take another 80 hours if they have another one of those reasons, qualifying reasons, and you would be able to claim tax credits on those 80 hours for that employee.
Right.
We can go flip to the next slide. If you have an employee on paid sick leave, the amount of pay they receive varies based on the reasons. So it's essentially if it's for the employee's own condition or own situation, which were reasons 1, 2, 3, and then the 2 new reasons, they're paid 100% of their rate of pay, or minimum wage if that's higher, up to $511 a day, $5,110 total, and that's the amount you can take for a tax credit. If the employee is caring for someone else, either a child whose school or care place is closed or somebody quarantining or isolating, they're paid 2/3 of their regular rate of pay, up to $200 a day and $2,000 total. And you can claim the tax credits up to those amounts. Okay, we can go to the next slide. So how does the paid FMLA work here? Okay, so going back to 2020, the expanded FMLA allowed employees 12 weeks of leave, 10 of which were paid for, in order to care for a son or daughter, a child whose school was closed or care provider was not available due to COVID-19. And they were paid at 2/3 their pay, and you could receive the tax credit for that. And that was the only reason that the FMLA expansion applied to, related to COVID. However, beginning April 1, paid FMLA is available for all of the reasons that are listed for the FFCRA paid sick leave reasons. So what that means is that if somebody is quarantining or self-isolating, and the most common situation would be if somebody is ill with COVID and they're ill for 3 or 4 weeks, they would receive 80 hours under the paid sick leave, and then the remaining, they'd be eligible for this paid FMLA then for the additional 2 weeks. So eligibility is slightly different. An employee needs to be have worked for the employer for 30 days in order to be eligible for this paid leave expansion. Okay, you can flip to the next slide, Rebecca. Employees are eligible for up to 12 weeks of paid FMLA. And here they're paid at a different rate than for the paid sick leave for all of the reasons. So for paid FMLA, it's 2/3 the employee's regular rate of pay, up to $200 a day, and a maximum of $12,000. So that was increased from $10,000 previously. And that's the amount that you can take a tax credit for a particular employee. So in that example I just gave, if an employee is ill with COVID for 4 weeks, the first 2 weeks would be paid sick leave at 100%, and then they would start receiving the paid FMLA at 2/3 their regular rate after that. One other interesting thing that ARPA did is it removed the 10-day waiting period before emergency FMLA begins to be paid. So before, there was this actual 10-day period where an employee didn't receive pay. However, that was generally filled in with the paid sick leave that they received. So even though they were still getting 12 weeks of leave total, the first 2 paid under the paid sick leave and then the remainder paid under FMLA. They've removed the 10-day waiting period. It's not entirely clear how this interacts with paid sick leave. Hoping likely there'll be some more regulations. What my interpretation is, and Rebecca, it'd be interesting if you have a different thought. My interpretation is that somebody gets one, or FMLA should still start at the beginning, and somebody's paid, really the higher of the two. So, and it specifically says in the tax in ARPA that you can't pay an employee both and get tax credits for both, right? So you would pay the employee the paid sick leave amount, which for some reasons might be 100%, and then they just wouldn't get any money, but they'd still be under this FMLA. They just wouldn't get double compensation. Is that how you've read it too?
Yeah, I mean, you can't pay both. So there are some additional ambiguity. Yeah, so you can't pay both. And so I think that's the best reasonable interpretation you could make, is to go with the more favorable outcome for the employee and read the two together. I had a good question in terms of someone posed, if someone didn't use the original 80 hours, would they be eligible for 160 hours through September? And the answer to that is no. The reset for all of this doesn't stack on top of what someone didn't use. If someone didn't use the time, that has expired.
Yeah. All right, and there's just one more slide if you want to flip to the last slide. So another new provision added here in the American Rescue Act is there are new non-discrimination rules. So the FFCRA tax credits are not available to employers who essentially discriminate in favor of highly compensated employees or full-time employees, or on the basis of employment tenure. So, in favor of employees that are longer service, or I read this to include in favor of employees who are shorter service, in providing the FFCRA benefits. So you need to provide them across the board without favoring those groups of employees if you're wanting to receive the tax credits. Were there any questions that you want to quickly address, Rebecca, or should we wrap up?
I was trying to skim them through a bit, and I think some of them you addressed, and the ones that I didn't get to were pretty specific where, maybe if you submitted something, I either thought it was addressed or the question was very specific where I couldn't answer it in the context without saying I would need more details. So I would encourage those of you who had a question or if you have additional ambiguities to reach out to one of us to follow up with maybe specifics of your scenario or your favorite attorney to do that. If you have a different favorite attorney at Smith Amundsen. The slides, again, just to reiterate, if you think you missed something or if you want to, we covered a lot of information very fast and it's new, some of it's very new stuff. If you want to go over it again and reprocess, provided nothing comes, we don't have any technical difficulties with the recording we attempted, we'll be able to distribute the link to a PowerPoint recording as well as the slide. You will definitely get the slides. I haven't had an issue yet with the PowerPoint, but or with the recording, but you never know, right? So I always have to put, again, my lawyer disclaimer. And I do apologize to those of you who didn't get to your questions. We had over 100 questions come through in the hour that we were talking. We had a lot of people on the webinar. So I think that, let me just take one quick scan, but yes, I think the biggest point for the FFCRA thing, Kelly, was just, the recommendation to take all of it or none of it based on what is currently there until we get other guidance. So you either choose to comply with all of it or you don't, that it's not pick and choose based on what we have right now, and that the reset means reset. It means start over. It means you don't pay attention to what was taken prior to, and everything starts with a clean counting system beginning April 1. And if you had any other comments to wrap up our questions, I think that should conclude our presentation for the day. Did you have anything you wanted to add before we close, Kelly?
Just the question on whether the FMLA 12 weeks resets. And unless there's guidance that provides otherwise, we believe that it does not reset.
Okay.
Yeah, so that's
all right.
That's it. So feel free to reach out to either one of us or both of us via email with any questions that you have.
Yes, and thank you again for joining us today, and have a good rest of your day today. Take care.